Jim Crow, as a cause and a consequence of the withdrawal of federal protections and support for black civil rights beginning in the early 1870s, came about because of political fatigue and economic depression. The great experiment in biracial rights, that is the era we call Reconstruction, ended rather abruptly in 1877 when the presidential election was so close that it fell to the US House of Representatives to choose the president. There, Republican Rutherford B. Hayes made a deal with Southern Democrats. These had been people who had supported Samuel Tilden. The Southerners agreed to support Hayes in exchange for his assurance that he would withdraw the last US troops from the South. Once he became president, he did this almost immediately. But such a political deal could not have occurred if US society was not ready to move on from supporting black civil rights, and it was. The white South, of course, never supported equal rights, and after the momentum of the Civil War wore off, Northern whites also reverted to disdain for black equality. Don't fool yourself into believing that even the most ardent white supporter of the Union wanted black equality. That was very rare. So after the war, and especially with the Depression of 1873, Northern supporters grew conservative and were willing to let the South come to its own equilibrium on racial matters. In addition to the removal of military forces to protect African American civil rights in 3 problematic states, the U.S. Supreme Court signaled that it would remove federal judicial protection of civil rights everywhere in the nation. I'll not go deeply into these cases, but I'll provide an overview in support of this claim that I just made. In 1873, the court decided the so-called Slaughterhouse Cases. Louisiana had given a monopoly to one slaughterhouse company in New Orleans and disallowed others from existing in their then current physical neighborhoods of New Orleans. This forced them to close. The slaughterhouses sued, saying that the state action had deprived them of property without due process, a violation of the 14th Amendment. The court decided that the 14th Amendment only applied to protecting the formerly enslaved, and that the amendment did not cover property rights of businesses. The ruling gave some power back to the states and accidentally weakened the ability of the federal government to protect black civil rights. In 1883, the court decided the civil rights cases, that is 5 cases from different jurisdictions that were combined together. The court struck down the Civil Rights Act of 1875, claiming the 14th Amendment only protected against state laws that discriminated, not private practices, and that companies could discriminate in public accommodations freely. This ruling opened the door to the first Jim Crow laws concerning rail cars that then led to the 1896 Plessy versus Ferguson case. 3 years later, in 1886, the court backtracked just a bit in the case called Yick Wo versus Hopkins. In 1880, San Francisco required licenses for all laundries that were in wooden buildings. Although 9 of every 10 laundries in wooden buildings were owned by Chinese operators, the licensing board refused to license any Chinese business. The court ruled that an administrative act that didn't mention race but was enforced in a discriminatory manner was illegal. Remember this, because it comes back in 1898. The most famous case in which the court removed federal support for black civil rights is Plessy versus Ferguson, decided in 1896. Most of us know what happened. Homer Plessy, a black man who could pass for white very easily, deliberately violated Louisiana's so-called Separate Car Act by refusing to move to the second-class rail car when ordered to do so by a conductor. Plessy had purchased a first-class ticket and had to convince the conductor that he was black, but he was arrested and fined. In 1896, the Supreme Court ruled that the Separate Car Act was constitutional, even though it specifically discriminated against blacks. But, wrote the court, that discrimination had to be ameliorated by providing facilities that were equal in quality, though separate. Second-class cars were smokers, and often just half of a mail car attached right behind the noisy, unclean engine, and they were rarely cleaned themselves. If a black person had purchased a first-class car ticket, like Homer Plessy did, the railroad company could not move them to a second car, to a second-class car. They had to provide first-class accommodations. Although Plessy's separate but equal formulation remained the theoretical shield of segregationists until it was overturned in 1954, the case of Williams versus Mississippi, decided in 1898, knocked the final underpinnings of federal protection out from under African American civil rights across the board. An all-white grand jury indicted Henry Williams for murder, and both the local court and the Mississippi Supreme Court sentenced him to hang. Williams appealed to the U.S. Supreme Court, claiming the indictment should be squashed because a local administrative officer had the sole ability to choose the jury pool from registered voter lists, from which most blacks were prohibited by a newly enacted voter suppression law in Mississippi. Williams argued that this violated the 14th Amendment, and it violated the court's Yick Wo decision. The Supreme Court ruled that because the text of the law in question did not mention race or deliberate discrimination, they were unconstitutional. It overturned its Yick Wo decision from just 13 years before. It also ruled that neither Williams nor any similar plaintiff could make a judicial case. Thus, the Williams decision allowed states free rein to enact any manner of discriminatory laws as long as they did not mention race. As we'll see, Southern states did just that, particularly disfranchising African Americans through changes in voter requirements. The Williams versus Mississippi is, to us, a defranchisement case. It was, to Henry Williams, a murder case. Washington County, Mississippi, on September 29, 1899, executed Henry Williams by hanging.